The aims and objectives of this session are to obtain that express, really squeezed roundup of the construction cases on a thematic basis, to understand what the current trajectory of the court is in relation to those, and therefore have a think about and tune into how industry is responding to them. For you, then, you can map the perspective from a commercial angle into your day-to-day work, and holistically enable yourselves as a takeaway to be able to think about these cases in that commercial perspective, and therefore advise and work on projects with more competence and more confidence. The judge in this case said very clearly that a competent designer would have called for a survey before finishing the design. Any intelligent consideration would have made the defendant realise that there was a serious possibility, given the context of this whole development, the defendant was doing a small part of it for the claimant, that the claimant would have some sort of financing arrangement in place. And the claimant's ability to pay that would be tied into the practical completion of the project, which was exactly what the claimant had said. If we could have handed it over earlier, we wouldn't have incurred these costs. So our starting point in terms of practical application is to remember that adjudication can be rough and ready. It is short and sharp. It is cost effective. It is within all the auspices of the Housing Grants Act and the scheme that goes with it. However, that rough and readiness must still be properly conducted. So this was a question about procedure. It was a question about clarity. And it was a question about fairness. Adding the dimension of insolvency again, if one of those parties becomes insolvent, then the other needs to act quickly in order to preserve its cash position, because insolvency can have the ability to prevent, albeit temporarily perhaps, the party from having its enforcement.